Before we begin, a quick and important disclaimer. This video is intended for educational and entertainment purposes only and does not constitute professional financial, legal, or tax advice. The laws surrounding divorce and retirement accounts vary significantly by state and individual circumstance. The information presented here reflects historical trends, case studies, and general economic principles as of 2026. You should always conduct your own due diligence and consult with a qualified attorney or a certified financial planner before making any decisions regarding your 401k, legal separation, or investment strategy. Most Americans believe the greatest threat to their retirement is a sudden stock market crash or a period of hyperinflation. They spend decades obsessing over expense ratios, asset allocation, and the latest tech stocks, convinced that if they just follow the math, they will reach the finish line of financial independence. But there is a silent legal trap that can evaporate 25 years of compounding growth in a single afternoon. It is a document that carries more weight than any bear market: a divorce decree. In the United States, we are currently witnessing a phenomenon where the primary vehicle for social mobility, the 401k, is being systematically dismantled by the reality of domestic dissolution. This isn't just about losing half of your money. It is about the structural destruction of the American middle class's ability to move upward. If you think your retirement is safe because the S&P 500 is up, you are missing the most volatile variable in the equation of your life. Today, we are performing a deep dive masterclass on the intersection of 401k litigation and U.S. social mobility. We will uncover how the legal mechanics of asset division are effectively resetting the wealth clock for millions of Americans, the specific technicalities of the qualified domestic relations order that most people ignore until it is too late, and why the current divorce trends are creating a new class of working elderly who did everything right, only to find the ladder of social mobility pulled out from under them at the age of 55. To understand the stakes, we first have to look at how the 401k became the linchpin of the American dream. Historically, social mobility was supported by the three-legged stool of retirement: Social Security, a company-funded pension, and personal savings. In the late 20th century, that stool was sawed down to a single leg for the vast majority of workers. Since the introduction of the Revenue Act of 1978, the responsibility for building wealth shifted entirely from the employer to the individual. The 401k became the primary, and often only significant asset for the U.S. middle class. Unlike a home, which requires maintenance and is subject to local real estate fluctuations, a 401k is a concentrated engine of compounding. It is the one tool that allows a person born into the lower middle class to potentially retire with the multi-million-dollar nest egg. However, because this asset is built over decades, it is inherently designed for stability. It assumes a linear progression of contributions and growth. When a marriage ends, that linear progression is not just interrupted, it is bifurcated. The statistical reality of 2026 shows a startling rise in what sociologists call gray divorce: couples over the age of 50 splitting up after 20 or 30 years of marriage. These are the years when 401k balances are at their peak. According to historical trends and recent case studies, a divorce at this stage typically results in a 50% reduction in retirement assets, but the economic impact is far greater than 50%. This is due to the loss of the velocity of compounding. When a $1 million 401k is split into two $500,000 accounts, both individuals lose the critical mass required to generate significant passive income. They are forced to return to the workforce or delay retirement, which effectively halts their social mobility. Instead of passing wealth down to the next generation, a key component of moving up the social ladder, the wealth is consumed by the friction of maintaining two separate households. Let's look at a step-by-step breakdown of how this wealth destruction occurs through the Qualified Domestic Relations Order, or QDRO. Most people assume that if a judge orders a 401k to be split, you just write a check. It is far more complex and dangerous than that. A QDRO is a legal directive that instructs a plan administrator on how to pay a portion of a participant's retirement benefits to an alternate payee, typically a former spouse. If the QDRO is drafted incorrectly, or if the timing is off, it can trigger massive taxable events. For example, in many case studies, we see individuals who receive a distribution from their former spouse's 401k, but fail to roll it into a qualified IRA within 60 days. In the eyes of the IRS, that isn't a split of assets. It's an early withdrawal. This can result in an immediate 10% penalty if the person is under 59.5, plus ordinary income tax. For a middle-class worker in a high tax bracket, a $200,000 split can turn into $120,000 after the government takes its cut. That is a 40% loss of mobility in a single transaction. The social mobility crisis is further exacerbated by the valuation date conflict. In a volatile market, the date a couple separates and the date the QDRO is actually executed can be months or even years apart. If the market drops 20% in that window, the participant might be forced to pay out a dollar amount based on a peak value that no longer exists, effectively leaving them with far less than half of the remaining assets. Conversely, if the market gains significantly, the alternate payee might miss out on thousands of dollars in growth. These technicalities aren't just legal minutiae. They are the difference between retiring in a home you own and spending your 70s in a rental unit. We also have to address the two-household problem. When a 401k is the primary asset, it is often used as a bargaining chip for the family home. One spouse keeps the house, the other keeps the 401k. On paper, this looks like an equitable 50-50 split. However, from a social mobility perspective, these assets are not equal. The house is a liability that requires property taxes, insurance, and repairs. The 401k is a productive asset that grows. Case studies show that the spouse who keeps the house often ends up house poor, unable to contribute to their own retirement, while the spouse who keeps the 401k has no place to live and is forced to pay market rate rent, which eats into their ability to let the 401k grow. Both parties find their upward trajectory frozen. The impact on the next generation is perhaps the most significant part of this deep dive. Social mobility in the U.S. is often a multi-generational project. Parents use their 401k stability to fund their children's education or provide down payment assistance for a first home. When that 401k is halved in a divorce, that surplus wealth vanishes. The children are then forced to take on student loans, which delays their own wealth building by a decade or more. The divorce reset doesn't just affect the two people in the courtroom. It creates a ripple effect that can demote an entire family line from the upper middle class back to a state of financial precariousness. This video deep dive will explore the potential outcomes for those navigating this landscape in 2026. We will examine historical trends that show how single-person households struggle to match the wealth-building power of a dual-income household. And we will look at the specific steps required to protect the compounding engine of your 401k, even in the face of legal dissolution. By the end of this 10-part masterclass, you will understand the hidden architecture of the U.S. retirement system and why the 401k is both the greatest tool for social mobility and the most vulnerable point of failure in your entire financial life. We are solving the problem of financial blindness, the idea that your net worth is a static number. It is not. It is a dynamic variable influenced by law, timing, and the structural integrity of your household. Let's get into the specific data on how the retirement reset is reshaping the American landscape. To understand the scale of the retirement reset, we have to look at the raw data defining the American middle class in 2026. For the first time in history, the median 401k balance for individuals in the 55 to 64 age bracket has crossed a significant threshold. Yet the cost of living has scaled even faster. When a household that has spent 30 years building a singular pool of wealth suddenly divides it, they aren't just splitting an account. They are doubling their overhead while having their growth engine. Consider the case of John and Sarah, a couple living in a high cost of living suburb of Atlanta. John is 54, working as a senior logistics manager, and Sarah is 52, a dedicated physical therapist. Together, they spent decades contributing to their respective 401ks, but the bulk of their wealth is concentrated in John's account because his employer offered a generous 6% match that they prioritized for 20 years. By early 2026, that account has reached $900,000. In a dual-income household, $900,000 represents a trajectory toward a comfortable, upper-middle-class retirement. It covers the mortgage, healthcare, and the potential to assist their children with graduate school. However, when John and Sarah decide to file for divorce, the legal reality of equitable distribution begins to dismantle that trajectory. In the state of Georgia, as in many other states, the portion of the 401k earned during the marriage is considered marital property. Imagine the moment they sit down with their mediators. The $900,000 is split down the middle. John is left with $450,000 and Sarah receives $450,000 through a legal mechanism we will detail later. On paper, they are both still wealthy by national standards. But the math of social mobility tells a different story. Historical trends suggest that the cost of maintaining two separate households is approximately 30 to 40% higher than maintaining one shared household. John now has to find a new apartment or purchase a smaller home at 2026 interest rates, which are significantly higher than the 3% rate they locked in for their family home in 2021. Sarah keeps the family home but now has to cover the entire mortgage, property taxes, and maintenance on a single salary. The $450,000 in their respective 401ks is no longer a surplus. It is a lifeline that is being stretched to its absolute limit. This is where the social mobility ladder breaks. Before the divorce, they were on track to enter the top 10% of wealth holders in their retirement years. Post-divorce, they both fall back into the middle of the pack, struggling to cover basic expenses while their peers, who remained married, continue to benefit from the compounding of a consolidated asset. The most devastating part of this reset is the loss of the velocity of compounding. In the world of finance, the size of your principal matters as much as your rate of return. A 7% return on $900,000 generates $63,000 in annual growth. That growth alone is often enough to cover a significant portion of a couple's retirement expenses without ever touching the principal. When that account is split into two $450,000 pools, each generates only $31,500. While the total growth remains the same, the individual's ability to live off that growth is eliminated because their individual expenses have not been halved. They are forced to start dipping into the principal to cover their new, higher cost of living. This creates a downward spiral where the principal shrinks, leading to less growth, which necessitates more principal withdrawals. For someone like John, who is only a decade away from retirement age, there is simply not enough time for the $450,000 to double and redouble to a level that provides the same security he once had. We also have to analyze the gender wealth gap that divorce introduces into the social mobility equation. Case studies from 2024 to 2026 consistently show that women often face a more steep decline in their standard of living following a midlife divorce. Sarah, despite having her own career as a physical therapist, may have taken years off or worked part-time when their children were younger. This resulted in lower lifetime earnings and fewer years of compounding in her own retirement accounts. Even with a 50% share of John's 401k, Sarah faces a unique set of challenges. Historically, women have a longer life expectancy than men, meaning her $450,000 needs to last 5 to 7 years longer than John's. Furthermore, the cost of healthcare in 2026 continues to rise, and as a single woman, Sarah lacks the informal caregiving support a spouse provides, potentially leading to higher long-term care costs down the road. For Sarah, the 401k split isn't just a financial setback. It is a threat to her fundamental independence. Imagine if John tries to catch up. He decides to maximize his contributions, hitting the 2026 limit of $30,000 plus the catch-up contribution for those over 50. Even with this aggressive saving, he is fighting against the clock. The potential outcomes for his retirement have shifted from luxury and travel to a cautious, budget-constrained existence. He is now part of the growing demographic of the working elderly. These are individuals who anticipated retiring at 62, but find themselves still in the office at 70 because their retirement engine was dismantled mid-career. This stagnation at the top of the career ladder also has a macroeconomic effect on social mobility for younger workers. When the Johns of the world can't afford to retire, the senior management positions don't open up, creating a bottleneck that prevents the next generation from moving up. The 401k divorce phenomenon is creating a new class of wealth in America: the resilient versus the reset. The resilient are those who manage to keep their household and assets intact, allowing the silent power of compounding to carry them into the upper echelons of society. The reset are those who, through no fault of their professional skill or work ethic, find their primary wealth-building tool cleaved in two. In 2026, the divide between these two groups is becoming the new baseline for inequality. It is not just about what you earn, it is about what you're able to keep together. As we look deeper into the mechanics of this destruction, we see that the legal process itself often becomes a predator of the very assets it seeks to divide. Legal fees, valuation experts, and the administrative costs of splitting a 401k can eat away another 3 to 5% of the total value before a single dollar is moved. For $1 million portfolio, that is $50,000 gone just to satisfy the process. This friction is a direct tax on the social mobility of the American middle class. But what if there was a specific mistake that could cost you an additional 40% of your share? Most people focus on the 50-50th split, but they completely ignore the tax implications of the transfer itself. There is a specific document, a specific set of words, and a specific timing that, if missed, triggers an immediate IRS intervention. Many people walk away from the divorce thinking they have $450,000, only to find out that the way the money was moved resulted in a massive taxable event that leaves them with barely $250,000. In the next part of this masterclass, we are going to dive into the technical nightmare of the Qualified Domestic Relations Order. We will look at why your divorce attorney might not be qualified to handle your 401k, and the one specific clause that determines whether your retirement stays in a tax-advantaged shell or gets decimated by the IRS. If you think the 50-50 split is the end of the story, you are unprepared for the tax bomb that is currently ticking inside millions of American retirement accounts. We will break down the exact steps to ensure that the transfer of assets doesn't become a liquidation event that ruins your financial future forever. The bridge between a divorce decree and the actual transfer of retirement funds is a document known as the Qualified Domestic Relations Order, or QDRO. While it may sound like just another piece of administrative paperwork, in the landscape of 2026, it is the most dangerous legal instrument a middle-class American will ever encounter. To understand why, we have to look at the massive disconnect between family law and federal retirement law. Most divorce attorneys are experts in state-level statutes regarding custody and asset division, but they are rarely experts in the Employee Retirement Income Security Act of 1974, known as ERISA. This gap is where social mobility goes to die. Imagine a case study involving a man named Michael, a 60-year-old structural engineer in Chicago with $1.2 million in his 401k. After 28 years of marriage, he and his spouse are finalizing their dissolution. The judge signs a decree stating that the 401k is to be split 50-50. Michael and his ex-spouse leave the courtroom thinking the hard part is over. They assume the court order is the final word. However, the court order has zero authority over the 401k plan administrator. Under federal law, the plan administrator at Michael's firm answers to ERISA, not the Cook County Circuit Court. Until a formal QDRO is drafted, approved by the plan, and signed by the judge, that money is legally locked. The first technical trap is the distinction between a separate interest and a shared interest. In 2026, this choice determines whether an individual can rebuild their life, or if they remain financially tethered to a ghost of their past. A separate interest QDRO effectively carves out a portion of the 401k and creates a brand new, independent account for the ex-spouse. This is the gold standard for social mobility. It allows the ex-spouse to choose their own investment allocations, name their own beneficiaries, and decide when to start taking distributions. For the ex-spouse, this is a clean break that allows them to continue the compounding process independently. However, many poorly drafted QDROs fall into the shared interest category. In this scenario, the ex-spouse does not get their own account. Instead, they are simply granted a right to a portion of each check that Michael receives when he eventually retires. Imagine if Michael decides to work until he is 75. His ex-spouse, who might be struggling with the high cost of living in 2026, is forced to wait 15 more years for a single dollar of that retirement money. They have no control, no ability to move the funds, and no way to use that capital to move up the social ladder. They are stuck in a state of financial suspension, all because of a few missing paragraphs in a legal filing. Then there is the issue of timing and market volatility. In the current 2026 economic climate, market swings of 3 to 5% in a single week are common. If Michael's QDRO specifies a fixed dollar amount such as $500,000, rather than a percentage of the account, he is taking a massive gamble. Consider a historical trend where a participant is ordered to pay a fixed $500,000 from a $1 million account. If the market corrections of 2026 cause that account to drop to $700,000 before the QDRO is processed, Michael is still legally obligated to pay the $500,000. He is left with $200,000, effectively losing 80% of his retirement value due to a drafting error. Conversely, if the account grows to $1.5 million, the ex-spouse misses out on the gains that occurred during the months of administrative processing. Step by step, the QDRO process is a minefield of administrative friction. First, the attorney must obtain the specific QDRO procedures from the employer's plan administrator. Every company, from Boeing to a local hospital, has different requirements. Second, a draft must be sent to the plan for pre-approval. This is where many cases stall for months. Plan administrators are notoriously slow, and if they find a single comma out of place or a term that contradicts their internal plan documents, they will reject it. During these months of delay, the participant might take out a 401k loan or change their investment strategy, further complicating the final division. We also have to look at the tax bomb hidden in Internal Revenue Code Section 72T. Under normal circumstances, taking money out of a 401k before age 59 and a half results in an immediate 10% early withdrawal penalty plus ordinary income tax. However, there is a specific exception for distributions made under a QDRO. This is a critical nuance that can either save or destroy a person's liquidity. If an ex-spouse needs immediate cash to secure a down payment on a new home in the 2026 housing market, they can take a direct distribution from the 401k through the QDRO process and avoid the 10% penalty. But there is a catch. If they instead roll that money into an individual retirement account or IRA, and then try to withdraw it for the down payment, the QDRO exception no longer applies. They are hit with the 10% penalty. In a case study of a 45-year-old teacher who rolled over $200,000 and then withdrew $50,000 for a move, that mistake cost her $5,000 in unnecessary penalties plus the associated taxes. For someone trying to re-establish a household on a single income, $5,000 is a significant blow to their mobility. Furthermore, the concept of gains and losses is often ignored in the rush to finish a divorce. If the decree says the spouse gets half of the 401k as of the date of separation, but the QDRO is not filed until 18 months later, what happens to the dividends and interest earned during those 18 months? If the document does not explicitly state that the award includes investment earnings and losses, the plan administrator may only pay out the base amount from 18 months ago. In a year like 2026, where interest rates and market volatility are high, the earnings on a large 401k over 18 months can be $40,000 or $50,000. Leaving that money on the table is a common way that individuals unknowingly sabotage their future standard of living. The structural destruction of wealth through the QDRO is not just a personal tragedy. It is a systemic barrier to the American dream. When 40% of marriages end, and the primary vehicle for wealth is the 401k, the legal system becomes a funnel that drains the middle class of its compounding power. The fees paid to QDRO specialists, who often charge thousands of dollars just to draft these documents, add yet another layer of cost. This is the divorce tax that no one talks about. It is a mandatory payment to the administrative state that provides no value to either party and only serves to slow down the process of economic recovery for the individuals involved. But what happens if the participant dies before the QDRO is finalized? Or what if they remarried and named a new spouse as the beneficiary? This creates a collision of rights that can lead to years of litigation in federal court, far beyond the scope of a simple divorce. In the next part of this masterclass, we are going to look at the nightmare scenario of the survivor benefit trap. We will examine how a single missing signature can allow a 401k to be inherited by a complete stranger, leaving a former spouse of 30 years with absolutely nothing. We will also dive into the 2026 data on how the rise of digital assets and side hustles is making the 401k split even more chaotic. If you think you are protected because you have a signed decree, the next chapter will reveal why you might still be standing on a financial trapdoor. The survivor benefit trap is perhaps the most harrowing example of how the 401k, an instrument designed for long-term security, can become a financial trapdoor. Imagine a woman named Linda, living in a suburb of Phoenix in 2026. After 32 years of marriage to a high-level executive named David, their divorce is finalized. The decree is signed, and it clearly states that Linda is entitled to 50% of David's $3,401,000. Linda breathes a sigh of relief, believing her future is secure. However, as we discussed, the decree is not the QDRO. While the lawyers are taking their time drafting the technical language of the QDRO, David unexpectedly passes away 3 weeks after the divorce is finalized. In this scenario, Linda is standing on the precipice of a total financial wipeout. Because the QDRO was not yet filed and approved by the plan administrator, the 401k plan still looks at the beneficiary designation on file. Under federal ERISA law, if David updated his beneficiary to a sibling, a new partner, or even a charitable trust immediately after the divorce was initiated, the plan administrator is often legally bound to pay the entire balance to that named beneficiary. The state court's divorce decree, which Linda holds in her hand, frequently carries no weight against the federal mandate of ERISA. Historical trends in federal court cases have shown that the plan must follow the documents on file with the employer. Linda, who spent 30 years contributing to the household and enabling David's career growth, finds her social mobility instantly revoked. She goes from a $3 million safety net to zero, all because of a 3-week administrative gap. This leads us into the remarriage collision, a phenomenon that is becoming increasingly common in 2026 as the pace of life and relationship transitions accelerates. Consider Robert, a 55-year-old manager in Chicago. His divorce from his first wife, Susan, is finalized, but the QDRO process is lagging. In the interim, Robert remarries a woman named Elena. Under the Internal Revenue Code and ERISA, a current spouse has immediate, automatic rights to a participant's 401k survivor benefits. If Robert were to pass away before Susan's QDRO is finalized and approved by the plan, Elena, the new wife, may have a superior federal claim to the retirement funds than Susan, the ex-wife, with the court order. This creates a high-stakes legal conflict known as an interpleader action. The 401k plan administrator, seeing two competing claims for the same money, will file a lawsuit against both women and deposit the funds into the court's registry, effectively saying to the judge, "You figure it out." The potential outcomes of these cases are often devastating for the retirement balance itself. The legal fees for an interpleader action are typically paid out of the 401k principal. By the time Susan and Elena finish litigating over who has the right to the wealth, a significant portion of that capital has been liquidated to pay attorneys. This is the structural destruction of wealth in real time. Instead of that money funding a retirement or an inheritance for Robert's children, it is consumed by the friction of the legal system. The complexity of the 401k in 2026 adds another layer of chaos to this process. Many modern 401k plans now include brokerage windows, which allow participants to invest in specific stocks, exchange-traded funds, or even digital asset trusts. Imagine if Robert's 401k wasn't just in a target date fund, but had a 20% allocation to a Bitcoin ETF. During the months it takes to finalize a QDRO, the volatility of digital assets can cause the total account value to swing by hundreds of thousands of dollars. If the divorce decree specified a dollar amount for Susan based on the value at the time of separation, but the digital assets crash before the transfer occurs, Robert could be forced to liquidate his remaining traditional assets just to cover the debt to his ex-wife. This leaves him with a hollowed-out retirement shell and no path back to his previous economic standing. Step by step, the integration of side hustle income into 401ks is also complicating the division of assets. In 2026, many professionals have solo 401ks or SEP IRAs in addition to their primary corporate 401k. They might be funneling consulting fees or e-commerce profits into these accounts. In a divorce, tracing the origin of these funds becomes a forensic nightmare. If a spouse can prove that the side hustle was started using marital assets or marital time, the entire growth of that secondary 401k is up for grabs. This creates a disincentive for entrepreneurial activity during a failing marriage, which in turn slows down the very mechanism of social mobility that these individuals are trying to utilize. We must also address the administrative backlog of 2026. While many financial tasks have been automated by artificial intelligence, the approval of QDROs remains a bottleneck. Major plan administrators are currently dealing with a record number of filings due to the gray divorce trend we mentioned earlier. A process that used to take 90 days can now stretch to 9 months. During this time, the participant is often prohibited from making changes to the account, taking loans, or even rebalancing their portfolio. They are effectively frozen in a market that doesn't stop moving. If a major economic correction occurs during this 9-month waiting period, both parties are forced to watch their shared future evaporate without the power to intervene. This is where the social mobility of the next generation comes into play. Historically, the 401k served as a silent guarantor for the American dream. It was the collateral that allowed parents to co-sign a child's first mortgage or provide the liquidity needed for a grandchild's education. When a 401k is locked in a multi-year legal battle between an ex-spouse and a current spouse, or when it is decimated by a poorly timed liquidation event, the ladder of mobility is pulled up for everyone in the family tree. The children of these divorces find themselves entering a 2026 economy without the safety net their parents worked decades to build. Imagine if there was a way to bypass this entire administrative nightmare. Some couples attempt to use an offsetting strategy, where one spouse keeps the 401k and the other takes an equivalent value in other assets, like a brokerage account or a piece of commercial real estate. On paper, this solves the QDRO problem, but in practice it creates a massive tax imbalance. The 401k is pre-tax money, the house is post-tax equity. In the 2026 tax environment, a dollar in a 401k is actually worth about 70 cents after you account for future income tax liabilities. If you trade a $600,000 house for a $600,401,000, you haven't made an even trade. You have just accepted a 30% reduction in your future purchasing power. This misunderstanding of tax-adjusted value is one of the primary reasons why midlife divorce leads to a permanent drop in social class. People focus on the nominal value of the assets rather than the utility of those assets in a post-divorce world. They fail to account for the fact that a 401k cannot be lived in, and a house cannot be easily liquidated to pay for groceries without taking on high-interest debt. But as complex as the 401k split is, there is an even more opaque part of the American wealth machine that is often completely overlooked in divorce negotiations. It is a hidden asset that can be worth more than the 401k itself, yet it doesn't show up on a standard balance sheet. It is the intangible value of professional licenses, degrees, and the future earning capacity built during the marriage. In the next part of this masterclass, we are going to dive into the controversial world of enhanced earning capacity and how the 2026 legal system is starting to put a price tag on your career itself. We will examine why your college degree might be considered marital property, and how this is creating a new form of lifetime alimony that is preventing thousands of high achievers from ever truly moving forward. If you think your 401k was the only thing at risk, wait until you see how the law is coming for your future paychecks. The concept of enhanced earning capacity is the final frontier of marital asset division, and perhaps the most controversial factor in the 2026 legal landscape. While the 401k is a bucket of money that already exists, enhanced earning capacity, or EC, is a claim on money that has not even been earned yet. In the United States, several jurisdictions have moved toward treating a professional degree, a license, or even a specialized career pivot as a marital asset that must be valued and divided. This isn't about alimony, which is designed to maintain a standard of living. This is about treating your career as a business that your spouse invested in, and therefore owns a piece of for the rest of your working life. For the high achiever looking to climb the ladder of social mobility, this can act as a permanent anchor, a career mortgage that never gets paid off. Consider the case of Marcus, a 38-year-old professional in Austin, Texas. In 2022, Marcus was a mid-level project manager earning $85,000 a year. With the full support of his wife, Chloe, Marcus decided to pursue an executive MBA followed by a specialized certification in artificial intelligence infrastructure. For 3 years, Chloe covered the majority of the household expenses, managed their 2 children, and effectively subsidized Marcus's transition into the tech elite. By early 2026, Marcus has landed a role as a senior AI strategist at a major firm, with a total compensation package of $450,000. Just as the family is about to leap from the middle class into the top 1% of earners, the marriage collapses. In a traditional view, the 401k they built during the marriage would be split. But in 2026, Chloe's legal team argues that the true asset isn't the $60,000 in Marcus's new 401k. It is the $365,000 annual salary increase Marcus achieved during the marriage. This is where the forensic accountants step in. To calculate the value of Marcus's enhanced earning capacity, they look at historical trends for his previous career path versus his new trajectory. They project his earnings over the next 25 years, adjust for inflation based on 2026 data, and then discount that total to a present value. If the accountants determine that Marcus's new degree and career pivot are worth a lifetime total of $5 million in extra income, Chloe may be awarded a significant percentage of that value as a lump sum or through an extended payment plan. Imagine the impact this has on social mobility. Marcus has the title and the high salary, but a massive portion of his after-tax income is legally committed to his ex-spouse. He has the appearance of wealth without the actual liquidity to build it. He cannot use his high salary to aggressively fund a new 401k, invest in real estate, or start a venture capital fund because he is effectively paying back a debt on his own brain. This is the success tax. It creates a ceiling on Marcus's ability to truly accumulate capital, effectively freezing him in a state of high income but low net worth. He is a high earner who is functionally stuck in the middle class because his primary asset, his ability to earn, has been bifurcated. The legal mechanics of this are even more complex when we look at the 2026 gig and creator economy. We are now seeing case studies where a successful YouTube channel or a high-traffic newsletter started during a marriage is treated as an asset with enhanced earning capacity. If one spouse acted as the editor or simply provided the financial stability for the other to build an audience, the court may view that audience as a marital product. Step by step, the valuation involves analyzing subscriber growth rates, historical trends in ad revenue, and the projected longevity of the niche. If you built a digital brand that earns $20,000 a month, you might find yourself in a position where you owe your ex-spouse $10,000 a month for the next decade, regardless of whether the algorithm changes or your views drop. This creates a massive deterrent to professional risk-taking post-divorce. If Marcus knows that 40% of any raise he gets will go directly to Chloe due to an EC award, his motivation to push for the next promotion or to launch a startup is significantly diminished. Social mobility is driven by the incentive to improve one's position. When the legal system removes a large portion of the reward for that improvement, it effectively stalls the engine of the American dream. We are seeing a trend in 2026 where individuals are choosing to remain in lower-paying, lower-stress jobs specifically to avoid triggering higher payments to an ex-spouse. This is a quiet crisis of productivity that is beginning to show up in national economic data. Furthermore, the interplay between the 401k and EC is a strategic battleground. In many negotiations, a spouse will offer to waive their claim to the 401k in exchange for a higher percentage of the other spouse's future earnings. At first glance, the spouse keeping the 401k thinks they have won. They have the liquid, compounding asset. But in the 2026 economy, where inflation can erode the purchasing power of a fixed 401k balance, the spouse who secured a percentage of a high earner's future salary may actually be the one who maintains their social mobility. They have an inflation-adjusted, royalty-style income stream that requires zero management and carries zero market risk. The high earner, meanwhile, is left with a 401k that they cannot touch for another 20 years, and a monthly bill that eats their current lifestyle. This brings us to the psychological reality of the working elderly. In 2026, we are seeing a spike in professionals in their 60s who are still working 60-hour weeks. These aren't people who love their jobs. These are people who are still paying off the EC or alimony obligations from a divorce that happened 15 years ago. They have become the ghosts of the upper class. Individuals who look the part and work the hours but have no hope of ever reaching true financial independence. Their 401ks are modest because they couldn't afford to maximize contributions while paying out their future earnings. Their social mobility has not just stalled, it has reversed. The 401k was designed to be the finish line, but the 2026 legal system has turned it into a starting point for a whole new set of obligations. If you are a high performer in the US today, your most valuable asset isn't your house or your retirement account. It is your future. And in a dissolution of marriage, that future is on the table just like a used car or a savings account. The potential outcomes of these cases are reshaping how Americans view career advancement. Is the promotion worth it if the legal cost of your previous life scales with your new success? But there is one final piece of the retirement puzzle that most people assume is untouchable. They think that even if the 401k is split and the future earnings are taxed, they can still fall back on the ultimate safety net provided by the US government. They believe that Social Security is their own personal account, protected from the reach of an ex-spouse. They are wrong. There is a specific set of rules known as the 10-year rule that can either provide a second chance at mobility or create a lifelong financial burden that you never saw coming. In the next part of this masterclass, we are going to expose the hidden mechanics of Social Security and divorce. We will look at why reaching your 10th anniversary is the most important financial milestone you've never been told about, and how the federal government can actually pay your ex-spouse more than you, without taking a single dime from your pocket. If you think you understand how your retirement benefits work, the reality of the Social Security split is going to change everything you thought you knew about the cost of staying or leaving. To understand why the 10-year rule is the most significant calendar event in a divorce, we have to look at how the federal government views the contract of marriage as an economic partnership. While a 401k is a private contract between you and your employer, Social Security is a social contract between you and the state. In the context of 2026, where the Social Security Trust Fund discussions are at a fever pitch and the cost of living has made every dollar of inflation-adjusted income vital, the ability to claim benefits based on an ex-spouse's work record can be the difference between a dignified retirement and falling into the ranks of the working poor. This is the one area of divorce where the pie actually gets larger rather than simply being divided. Imagine a case study involving a couple named Tom and Karen living in suburban Ohio in 2026. Tom has been the primary earner for nearly a decade, working as a senior project manager in the construction industry. while Karen transitioned out of the full-time workforce to manage their household and support their 3 children. As they approach their 10th anniversary, the marriage has reached a breaking point. For Karen, the timing of the divorce filing is not just a matter of emotional readiness. It is a calculation that will affect her social mobility for the next 40 years. If Tom and Karen divorce at 9 years and 11 months, the Social Security Administration views their marriage as if it never happened. Karen is left to rely solely on her own work record, which, due to her years of caregiving, may result in a monthly benefit that barely covers a fraction of her 2026 rent. However, if they reach the 10-year mark, Karen becomes eligible for what is known as a divorced spouse benefit. Under this federal mandate, Karen can receive up to 50% of Tom's full retirement age benefit amount, provided she is at least 62 years old and remains unmarried. The most critical distinction that many people miss in 2026 is that this does not reduce Tom's benefit by a single penny. Unlike the 401k split, which we have seen can leave the participant with a hollowed-out account, the Social Security derivative benefit is a separate entitlement created by the government. If Tom goes on to remarry, his new wife is also entitled to benefits based on his record. In theory, the federal government could be paying out benefits to a participant, an ex-spouse, and a current spouse, all based on the same lifetime earnings. This is a massive, hidden subsidy for social mobility that most people fail to leverage because they rush to finalize their paperwork just months before the 10-year threshold. Historical trends show that this rule creates a unique form of leverage in divorce negotiations. In Karen's case, her attorney may advise her to delay the final decree until the 10-year anniversary has passed. This isn't about greed. It is about establishing a financial floor. In the 2026 economy, where private pensions are non-existent and 401ks are subject to the whims of a volatile market, an inflation-adjusted, government-backed check is an invaluable asset. It provides a level of certainty that allows a divorced individual to take more risks with their other assets, such as investing in a small business or pursuing further education, which are the traditional drivers of upward mobility. However, the 10-year rule is a minefield of secondary requirements. One of the most significant potential outcomes involves the remarriage trap. If Karen remarries before the age of 60, she loses her eligibility to claim on Tom's record. This creates a strange and often painful economic incentive in 2026. We are seeing a rise in cohabitation without marriage among the divorced population over 50, specifically to preserve these Social Security entitlements. For many, the risk of losing $1,000 or more in monthly, inflation-protected income is too high a price to pay for a second legal marriage. This shift is changing the social fabric of the American middle class, as financial survival dictates the structure of personal relationships. Step by step, the process of claiming these benefits in 2026 requires meticulous record-keeping. An ex-spouse must be able to provide the Social Security Administration with a marriage certificate and a final divorce decree. They also need the participant's Social Security number. If the divorce was acrimonious and the participant refuses to provide this information, the ex-spouse can still move forward, but the administrative hurdles increase significantly. Furthermore, there is a 2-year waiting period if the divorce has been final for less than 2 years, and the participant has not yet applied for their own benefits. This delay can be a major roadblock for someone trying to stabilize their finances immediately after a split. The impact of these rules on social mobility is especially pronounced when we consider the survivor benefit. If Tom were to pass away after they have been divorced for 10 years, Karen is eligible to receive 100% of his benefit amount, rather than just 50%. In a 2026 scenario where Tom's benefit might be $3,000 a month and Karen's own record only entitles her to $1,200, the death of an ex-spouse can suddenly and dramatically increase her standard of living. It is a morbid but undeniable reality of the U.S. retirement system. Your social class in your 80s may depend entirely on the career success of a person you haven't spoken to in 30 years. We must also look at the earnings test in the 2026 economic environment. Many divorced individuals find they must continue working well into their 60s to make ends meet. If Karen claims her divorced spouse benefit before her full retirement age, which for those born after 1960 is 67, and she continues to earn above a certain threshold, her benefits will be temporarily reduced. For every $2 she earns above the limit, the government withholds $1 of benefits. This can create a productivity trap, where working harder actually results in less total income in the short term, effectively capping her ability to build back the wealth lost in the 401k split. The intersection of the 401k, the QDRO, and Social Security creates a complex web that defines the trajectory of the American middle class. If you lose half your 401k but secure a high Social Security derivative benefit, your social mobility might be preserved. If you lose the 401k and miss the 10-year Social Security mark, your path to the upper class is likely closed forever. This is why the deep dive into the technicalities is so important. Most people view divorce as a legal and emotional event, but it is primarily a structural economic event that resets your position in the hierarchy of U.S. wealth. As we move forward in this masterclass, we have to address the largest single asset most Americans own, which often becomes the most emotional and financially ruinous part of any settlement. It is the family home. In the 2026 housing market, where inventory is low and interest rates have fundamentally changed the math of ownership, the decision to keep the house or sell, it is no longer a simple one. Many people trade their entire 401k just to stay in their home, not realizing they are walking into a liquidity trap that will eventually force them into a lower social class. In the next part of this masterclass, we are going to look at the housing trap. We will break down why keeping the family home is often the worst financial decision you can make in a divorce, and how the 2026 mortgage landscape is creating a new class of equity-rich but cash-poor individuals. We will examine the hidden costs of property taxes and maintenance that can turn a suburban dream into a social mobility nightmare. If you think the house is your greatest asset, the next chapter will show you why it might actually be the anchor that sinks your retirement. The primary reason the family home becomes a trap is rooted in a psychological bias known as the endowment effect, where we overvalue what we already own. In a 2026 economic environment characterized by high property taxes and insurance premiums that have outpaced inflation for 5 consecutive years, this bias is becoming a primary driver of downward social mobility. When a couple divorces, the most common instinct is to maintain some form of stability for the children, and that usually means keeping the house. However, in the math of asset division, the house is often traded for the 401k. One spouse keeps the $800,000 residence with $300,000 in equity, while the other spouse keeps the $300,000-$401,000. On a balance sheet, this looks like an even split of $300,000 in net worth. In reality, these two individuals are now on completely different economic trajectories. Imagine a case study involving Amanda, a 48-year-old pharmaceutical sales representative in Denver. In early 2026, Amanda and her husband decide to split. They have a home valued at $900,000 with $400,000 of equity remaining. Amanda is determined to keep the house to avoid uprooting her 2 teenagers. To make the trade equitable, she waives all rights to her husband's $401,000. Amanda feels she has won because she has the physical asset and a stable roof. However, the first trap she encounters is the refinancing requirement. Most divorce decrees require the spouse keeping the home to remove the other spouse from the mortgage within 6 to 12 months. In the 2026 mortgage market, interest rates are significantly higher than the 3% rate Amanda and her husband locked in back in 2021. To refinance and take out enough cash to pay off her ex-husband's share of the equity, Amanda is forced to move from a $3,000 monthly payment to a $6,500 monthly payment. Suddenly, 60% of her take-home pay is dedicated to housing. This is the definition of being house poor. While her ex-husband's $401,000 is sitting in a diversified portfolio of stocks and bonds, compounding at an average rate of 7 to 9%, Amanda's equity is locked in a non-productive asset. She cannot use the equity in her walls to buy groceries or pay for the rising costs of utilities, which in 2026 have spiked due to new regional energy grid taxes. Step by step, the liquidity trap begins to close. Because Amanda is spending so much on her mortgage, she stops contributing to her own 401k. She misses out on the employer match and the tax advantages of retirement saving. Over a 10-year period, the opportunity cost is staggering. Historical trends suggest that while real estate in Denver may appreciate by 3 to 4% annually, a well-managed 401k can easily outpace that growth. More importantly, the 401k is liquid and divisible. The house is an all-or-nothing proposition. If Amanda needs $50,000 for an emergency, she can't just sell the kitchen. She has to take out a high-interest home equity line of credit, which further increases her monthly overhead and erodes her mobility. We also have to analyze the hidden costs of the 2026 housing landscape, property tax reassessments, and the insurance crisis. In many states, a change in title due to divorce can trigger a property tax reassessment. If Amanda's home was originally purchased for $400,000 and is now worth $900,000, her property tax bill could double overnight. Simultaneously, insurance companies in 2026 have become increasingly selective, raising premiums by 40% in areas prone to wildfires or hailstorms. Amanda, now on a single income, is responsible for 100% of these costs. Case studies of midlife divorcees show that within 5 years of keeping the family home, 40% are forced to sell anyway because the maintenance and carrying costs have decimated their savings. By the time they sell, they have lost years of compounding in their retirement accounts and are entering the housing market as buyers at an even older age, with even less time to recover. Imagine if Amanda had made the opposite choice. If they had sold the home, split the $400,000 equity, and Amanda had taken her $200,000 to buy a smaller townhome or even rent while keeping her share of the 401k. She would have maintained her liquidity and her ability to continue investing. Her social mobility would be preserved because her wealth would be working for her, rather than her working for her house. But the emotional weight of the suburban dream often blinds people to this outcome. They see the house as a status symbol of the life they once had, failing to realize it has become a liability that prevents the life they could have. The social mobility of Amanda's children is also at stake. Parents often keep the house to keep the kids in a specific school district. But if the cost of that house means the parents cannot afford to help with college tuition or provide a safety net when the children enter the workforce, the long-term mobility of the children may actually be lower. In 2026, the value of a debt-free start for a young adult often outweighs the value of staying in a specific zip code for the last 3 years of high school. The housing trap creates a situation where the family is equity-rich but lifestyle poor, leading to a state of constant financial stress that impacts every aspect of their well-being. Furthermore, there is the issue of capital gains taxes. If Amanda keeps the house and eventually sells it years later, she only has a $250,000 capital gains exclusion as a single filer. If they had sold the home while still married, they would have had a $500,000 exclusion. By keeping the house, Amanda has potentially inherited a future tax bill that further reduces the net value of the asset. This is another example of how the legal and tax structures of 2026 are not designed for the modern reality of marital dissolution. Every decision made in the heat of a divorce has a long-term tax consequence that can shave hundreds of thousands of dollars off a person's lifetime net worth. As we look at the destruction of the 401k and the anchor of the family home, we are seeing a structural shift in the American class system. The people who navigate these transitions by prioritizing liquidity and compounding are able to maintain their status. The people who prioritize sentiment and physical assets often find themselves sliding down the ladder. In 2026, wealth is no longer about what you own. It is about the flexibility and growth potential of your assets. The family home, once the ultimate engine of the middle class, has become a high-maintenance luxury that many divorced individuals simply cannot afford to subsidize. But even if you manage to navigate the 401k split and avoid the housing trap, there is an invisible force that can still pull you down. It is a force that doesn't appear in the divorce decree but follows you to every bank, every car dealership, and every potential employer. It is the ghost of your ex-spouse's financial behavior. In the next part of this masterclass, we are going to dive into the credit afterlife. We will examine how joint debt, co-signed loans, and shared credit histories can haunt your social mobility for years after the ink is dry on your divorce. We will reveal the specific steps to decouple your financial identity in 2026, and why a single missed payment by your ex can tank your ability to rebuild your life. If you think you've made a clean break, you haven't seen your new credit report yet. The invisible ghost of your former life manifests most aggressively in the digital archives of the 3 major credit bureaus. In the 2026 economy, where data aggregation is instantaneous and algorithmic risk assessment dictates everything from your car insurance premiums to your ability to pass a background check for a high-level corporate position, your credit report is the foundational document of your social mobility. Many people believe that once the judge signs the divorce decree and the assets are divided, their financial identity is successfully decoupled. This is a dangerous misconception. A divorce decree is a legal agreement between 2 individuals and a state court. It is not a contract that binds a third-party creditor like a national bank or a mortgage lender. Imagine a case study involving a man named David, a 45-year-old cybersecurity analyst living in Northern Virginia. In early 2026, David finalized his divorce from his spouse, Sarah. The court ordered Sarah to take full responsibility for a joint credit card with a $15,000 balance and the lease on a luxury SUV they had acquired a year prior. David, believing he was protected by the court's order, moved into a temporary rental and began the process of rebuilding his solo life. He had a credit score of 790, which allowed him to access the best interest rates available in a high-rate 2026 environment. However, 6 months later, David applied for a mortgage to purchase a modest townhouse. He was shocked when his application was summarily rejected. His credit score had plummeted to 610. The reason was simple but devastating. Sarah, struggling with the increased cost of living as a single parent, had missed 3 consecutive payments on the joint credit card and fell 60 days behind on the SUV lease. Because David's name remained on the original contracts with the lenders, the banks reported the delinquency to his credit profile as well as hers. In the eyes of the financial system, David was not a victim of a divorce settlement. He was a high-risk debtor who had failed to meet his contractual obligations. This is the reality of joint and several liability. When you sign a loan agreement with a spouse, you are both 100% responsible for the debt. The bank does not care who the judge said should pay. They only care that the person who signed the contract is paying. In the 2026 landscape, the potential outcomes for someone in David's position are increasingly bleak. A credit score drop of nearly 200 points doesn't just prevent you from buying a home. It triggers a cascade of financial penalties. His existing credit card companies, seeing the drop in his score via soft pull monitoring, immediately lowered his credit limits and raised his interest rates to the default maximum of 29%. His auto insurance provider, which uses credit-based insurance scores, increased his semi-annual premium by $400. This is a direct drain on the liquidity David needs to fund his 401k and maintain his upward mobility. He is now trapped in a cycle where he is paying a premium for his existence simply because his ex-spouse's financial behavior is still tethered to his identity. Step by step, the decoupling of financial identities must be proactive rather than reactive. The first critical step is the immediate closure of all joint accounts. In 2026, many banks allow for the freezing of joint lines of credit during a pending divorce to prevent what is known as spite spending. Imagine if Sarah, in a moment of emotional distress, had maxed out a $50,000 home equity line of credit. David would have been legally responsible for that debt regardless of how the money was spent. Historical trends show that the most successful financial transitions occur when couples convert joint debt into individual debt before the final decree is even signed. This might involve taking out individual personal loans to pay off a joint credit card or refinancing a vehicle solely in the name of the person keeping it. Furthermore, we have to address the authorized user trap. Many couples add each other as authorized users on their individual accounts to help build credit or simplify household spending. Even if David owned a credit card in his name only, if Sarah was an authorized user, her spending could still impact his debt-to-income ratio. More importantly, if David was an authorized user on one of Sarah's accounts, her late payments would reflect on his report. In 2026, removing an authorized user is a simple digital process, yet it is often overlooked in the chaos of a split. A single forgotten retail card from a decade ago can become the anchor that drags down a person's ability to qualify for the high-limit credit lines necessary for modern business ventures or real estate investments. The 2026 job market adds another layer of complexity. For professionals like David in the cybersecurity or financial sectors, credit checks are a standard part of the annual recertification or security clearance process. A significant drop in credit score can be interpreted as a sign of financial instability, making an individual more susceptible to bribery or internal fraud. In this high-stakes environment, Sarah's missed payments could literally cost David his career. This is how the 401k divorce and the credit afterlife intersect to destroy social mobility. If David loses his high-paying job because of his credit score, he loses his ability to contribute to his retirement, and his previous 30 years of labor are effectively neutralized. Consider the indemnification clause that many lawyers include in divorce decrees. This clause states that if Sarah fails to pay the debt and the bank comes after David, Sarah must reimburse David for his losses. While this sounds like a solid protection, in practice it is often a hollow promise. If Sarah is missing payments because she has no money, an indemnification clause is just an expensive piece of paper. David would have to hire an attorney, go back to family court, and attempt to find David in contempt, all while his credit score continues to bleed and the banks continue their collection efforts. The legal fees for this process in 2026 can easily exceed $5,000, further depleting David's remaining capital. The most effective strategy for preserving mobility in this stage is the total identity reset. This involves pulling all 3 credit reports, Equifax, Experian, and TransUnion, and identifying every single shared account, no matter how small. It requires a systematic approach, closing joint accounts, removing authorized users, and placing a credit freeze on all profiles to prevent the opening of new joint accounts without explicit consent. In the 2026 digital age, identity theft by an ex-spouse is a rising trend. Having access to David's social security number and personal history, Sarah could theoretically open new lines of credit in David's name just to stay afloat. Without a credit freeze, David might not discover this for years. This credit afterlife is the silent killer of the American dream post-divorce. It creates a shadow debt that doesn't show up in the asset division, but dictates the quality of your life for the next decade. If you cannot maintain a high credit score, you cannot access the leverage required to move from the middle class to the wealthy class. You are relegated to the subprime economy, where everything costs more and the path to recovery is paved with high-interest obstacles. But as we look at the wreckage of credit scores and divide it for 401ks, there is a final, even more complex variable that determines who survives a divorce with their social mobility intact. It is the hidden cost of the next generation. In 2026, the way we fund education and support adult children has changed, and the divorce decree is now reaching into the future in ways that previous generations never anticipated. In the next part of this masterclass, we are going to explore the generational drain. We will look at how college tuition mandates and the rise of support for adult children clauses are creating a new form of indefinite financial obligation. We will examine why your 401k might not be for your retirement at all, but rather a court-mandated tuition fund for a child who hasn't even finished middle school yet. If you think the financial bleeding stops once the kids turn 18, the 2026 legal reality is about to prove you wrong. In the United States legal system of 2026, a fundamental shift has occurred in how the state views the transition from childhood to adulthood, specifically within the context of dissolved marriages. For a married couple, the decision to fund a child's college education is a matter of personal choice and family discretion. There is no federal or state law that mandates a married parent to pay for a university degree. However, once a divorce is finalized, that parental autonomy often vanishes, replaced by court-mandated obligations known as educational support orders. This is the moment where the 401k, which was painstakingly preserved through the QDRO process we discussed earlier, faces its second and perhaps more aggressive predator. Consider a case study involving Jennifer, a 54-year-old nurse manager in New Jersey, a state that has historically led the trend in mandated college contributions. In early 2026, Jennifer is 3 years post-divorce. She managed to keep $600,000 of her 401k intact by sacrificing her share of the family home's equity. She believes this $600,000 is her final safety net, the engine that will allow her to maintain her middle-class status in retirement. Her daughter, Maya, is now a high school senior and has just been accepted into a prestigious private university in California. The total cost of attendance for 2026, including tuition, housing, and the now mandatory digital infrastructure fees, is projected at $98,000 per year. Jennifer's ex-husband, who has a lower income but higher liquid savings, files a motion for contribution. The court applies a set of factors, often referred to in legal circles as the Newberg factors, to determine Jennifer's share. The judge looks not just at Jennifer's current salary, but at her total financial resources. In the 2026 legal climate, the $600,000 sitting in her 401k is not seen as off-limits. It is viewed as an available asset. The potential outcome is a court order requiring Jennifer to contribute 40% of Maya's college costs. Over 4 years, that is a $156,000 obligation. Jennifer does not have this in cash. To meet the legal requirement, she is forced to do the unthinkable. She must tap into her 401k. Step by step, the destruction of Jennifer's social mobility accelerates. Because she is under 59 and a half, any withdrawal she makes from her 401k to pay the bursar's office is treated as an early distribution. Even though a 2026 court ordered the payment, the IRS does not recognize a college tuition mandate as an exception to the 10% early withdrawal penalty. To net the $39,000 needed for Maya's freshman year, Jennifer must actually withdraw roughly $55,000. This covers the $39,000 for the school, the $5,500 for the 10% penalty, and approximately $10,500 for state and federal income taxes. In 1 year, Jennifer has liquidated nearly 10% of her retirement engine. The compounding loss is the silent killer here. By taking out $55,000 in 2026, Jennifer isn't just losing that cash. She is losing the potential growth of that money over the next 15 years. If that money were left to grow at a historical trend of 7%, it would have been worth approximately $150,000 by the time she reached 70. By the time Maya graduates, Jennifer's 401k has been reduced from $600,000 to less than $400,000, and she has missed out on 4 years of market gains during a period of 2026 recovery. Maya graduates debt-free, which is a massive boost to her own social mobility, but Jennifer has effectively traded her upper-middle-class retirement for her daughter's head start. This is the generational wealth swap, and it is becoming the standard exit strategy for the American middle class. But the generational drain does not stop at the graduation ceremony. In 2026, the United States is seeing a rise in failure to launch litigation. Due to the extreme cost of housing and the saturation of the entry-level job market, many adult children are returning home or remaining financially dependent on their parents well into their 20s. In several jurisdictions, attorneys are now successfully arguing for the extension of child support or adult maintenance for children who have graduated college but have not yet achieved financial independence. Imagine if Maya, after graduating in 2030, struggles to find a role that covers the high cost of urban living. Jennifer's ex-spouse could potentially move to extend support obligations, further delaying Jennifer's ability to replenish her retirement funds. We must also analyze the 529 plan trap. Many parents in Jennifer's position believe they were being responsible by setting up 529 college savings plans years in advance. However, in a 2026 divorce, the ownership of the 529 plan is a major point of contention. If the 529 plan is owned by the ex-husband, he may have the right to change the beneficiary or use the funds in a way that doesn't reduce Jennifer's court-ordered contribution. Historical trends show that unless the divorce decree specifically identifies the 529 plan as the primary and sole source of college funding, the court may view it as a separate asset, still leaving the parents' 401ks vulnerable to additional tuition mandates. Furthermore, the sandwich generation effect is peaking in 2026. Jennifer is not just being squeezed by Maya's tuition, she is also likely managing the care of her own aging parents. In many modern divorce settlements, we are seeing the emergence of elder care clauses, where spouses agree to share the costs of nursing homes or home health care for their respective parents. When you combine an educational support order and elder care obligation, and a halved 401k, the math of social mobility simply stops working. The individual is no longer building wealth, they are merely acting as a clearinghouse for the financial needs of the generations above and below them. This creates a new demographic in the U.S., the new poor. These are individuals who, by all outward appearances, are successful. They are nurses, engineers, and managers earning six-figure salaries. But because their primary wealth-building tool, the 401k, has been redirected toward the education of the next generation and the care of the previous one, they have a negative net worth as they enter their 60s. They are the first generation in American history that will likely have a lower standard of living in retirement than their parents did, despite earning significantly more during their working years. The potential outcomes for Jennifer are now limited. She cannot retire at 65. To maintain any semblance of her previous life, she will likely have to work until 75 or 80. This stagnation at the senior level of the workforce prevents younger nurses from moving into management roles, creating a ripple effect that slows social mobility for the entire economy. The 401k divorce is not a private matter. It is a structural failure of the American dream. But even in this landscape of mandates and wealth drains, there is a path toward a final algorithm for recovery. There are specific high-level strategies used by the top 1% to insulate their mobility from these legal traps. As we approach the conclusion of this masterclass, we have to look at how to rebuild from the wreckage. In the final part of this series, we are going to reveal the recovery blueprint. We will examine the 2026 backdoor strategies that allow for rapid wealth reconstruction, the psychological shifts required to stop the bleeding, and the one final move that can decouple your future from the legal ghost of your past once and for all. If you have been stripped of your 401k, your home, and your credit, the final chapter is your only map back to the top. The process of rebuilding from a financial zero point in 2026 requires more than just hard work. It requires a surgical application of the current tax code and a complete psychological decoupling from the lifestyle expectations of your previous marriage. When you are standing in the wreckage of a halved 401k, a lost home, and a bruised credit score, the traditional advice of just save more is insufficient. You are fighting against the most compressed timeline of your life. For those in their late 40s or early 50s, the potential outcomes for a comfortable retirement depend entirely on maximizing the velocity of recompounding. This is the stage where we transition from the defense of asset division to the high-stakes offense of wealth reconstruction. The first pillar of the recovery blueprint involves the aggressive utilization of the 2026 catch-up provisions. Under the historical trends established by the Secure Act 2.0 and subsequent 2026 cost of living adjustments, individuals over the age of 50 have access to significantly higher contribution ceilings. Imagine a professional named Mark, age 55, who just watched his 401k drop from $1 million to $500,000 after his QDRO was finalized. To rebuild, Mark must prioritize the maximum contribution limit, which in 2026 has climbed to $30,000, plus a catch-up contribution of $7,500. But the deep dive strategy doesn't stop there. Mark must also look at the 2026 HSA limits. A health savings account is often called the Super IRA because it offers a triple tax advantage: pre-tax contributions, tax-free growth, and tax-free withdrawals for medical expenses. By funneling the maximum $4,500 into an HSA and treating it as a long-term investment vehicle, rather than a spending account, Mark is creating a secondary tax-protected engine that can cover the astronomical healthcare costs projected for the late 2030s. Step by step, the next phase of the blueprint is the backdoor conversion. In the 2026 tax environment, many high earners find themselves phased out of direct Roth IRA contributions. However, the backdoor Roth strategy remains a critical tool for social mobility. By contributing to a non-deductible traditional IRA and immediately converting it to a Roth, Mark can ensure that at least a portion of his future growth is entirely shielded from the tax man. When you are starting with half the principal, you cannot afford to give away 25 to 30% of your future gains to the IRS. This is the math of the recovery. Every percentage point saved in taxes is a percentage point added to your compounding velocity. Geographic arbitrage is the third, and perhaps most disruptive, tool for rebuilding. In 2026, the rise of remote-first executive roles has made it possible to maintain a high-tier salary while slashing cost of living expenses. Case studies of successful post-divorce recoveries often show a common thread. The individual leaves a high-tax, high-cost state like California or New York for a zero-income tax state like Florida, Texas, or Tennessee. For someone like Mark, moving from a city with a 5% state income tax to a zero-tax state effectively grants him an immediate 5% raise. If he redirects that 5%, roughly $15,000 on a $300,000 salary, directly into a brokerage account, he is adding nearly $150,000 to his net worth over a decade, not including market growth. This isn't just about moving. It is about reclaiming the margin that the divorce settlement took away. We also have to address the side hustle solo 401k, for those whose enhanced earning capacity was a central theme of their divorce. In 2026, the gig economy is no longer just for entry-level workers. It is for consultants, advisors, and digital creators. If you have any form of self-employment income, you can open a solo 401k, which allows for much higher contribution limits than a standard corporate plan, up to $69,000 or more depending on your income levels. This allows the reset class to bypass the limitations of their day job's retirement plan and move capital into a protected shell at twice the normal speed. Imagine if Mark consults on the side, earning $50,000 a year. By pumping that entire amount into a solo 401k, he is effectively neutralizing the loss of his 401k split within a matter of years. The psychological shift required for this recovery is what we call the new zero. Many people fail to rebuild because they are constantly comparing their current lifestyle to the one they had when they were married. They try to keep the luxury car or the expensive club memberships to prove they haven't fallen. This is a recipe for permanent social stagnation. The high retention strategy for 2026 is to embrace a monk-like financial focus for a period of 36 to 48 months. By cutting expenses to the bone during the initial recovery phase, you allow the first $100,000 of your new principal to reach critical mass. Historical trends in wealth building show that the first 100,000 is the hardest to accumulate. Once you reach that point, the money begins to do the heavy lifting for you. But what about the risk of a second divorce? In 2026, gray remarriage is at an all-time high, and with it comes a new level of legal precaution. The recovery blueprint is incomplete without a post-dissolution asset protection strategy. This involves the use of domestic asset protection trusts or highly specific prenuptial agreements that treat the rebuilt 401k as separate, non-marital property from day one. If you are entering a new relationship in your 50s, you are no longer just a romantic partner. You are a fiduciary for your own future. The 2026 legal system is far more accommodating to these business-first approaches to marriage than it was a decade ago. Protecting your second act is just as important as building it. The macroeconomic impact of this reset class is reshaping U.S. social mobility. We are seeing a divergence between those who fall victim to the retirement reset and those who use it as a catalyst for a more efficient, high-growth second half of life. Social mobility is not a one-way street. It is a series of climbs, falls, and reclimbs. In 2026, the most mobile individuals are those who understand that wealth is a function of system design rather than just a high salary. By mastering the QDRO, the credit afterlife, the generational drain, and the recovery blueprint, you are not just surviving a divorce. You are re-engineering your financial destiny. As we conclude this deep dive masterclass, we have to look at the final, most important question. Even if you follow every step, even if you maximize every tax shield and move to a zero-tax state, there is one variable that can still override everything. It is a decision that most Americans make in their 60s that permanently locks them into a specific social class for the rest of their lives. It involves the timing of the most significant check the government will ever write to you. In the next phase of your financial journey, you will have to decide: is the bird in the hand worth the decades of compounding you are leaving on the table? We will explore the final conflict between immediate security and generational wealth in the ultimate guide to the longevity pivot.